Good evening. Welcome to this special edition, a bonus live stream tonight. I'm excited to be here tonight. Hope you guys have a little bit of time on your hands because we have a document that just dropped that we have to get to right now. Oh my goodness. I'm so excited about this. This is back to the Young Thug case. Oh, let's see. I need to find it now. Where did my document go? It's missing. It'll turn up somewhere. Weird intro this morning. I got the music, but not the words. But you guys can sort of just mouth the words along with that. But we're gonna get started here in just a minute. Let me make sure we've got everything where I need it. I think we do. I think we're good. I have no idea who is first in chat today. Let's see. Let me do a quick check and see if I can find them. Let's see. Pause this guy. We need some volume there. All right.
This is all the apocalypse.
There's
Maybe
the volume.
upon us.
Oh, look at this. I think we had a gifted membership. First thing. Who was that? How do I show that? Oh, just 1 second. We're going to kick this off. It looks like Janice gifted a membership first thing. Janice, you were maybe first in chat. Let's see if we can sort this a little bit differently. See who was actually first. There we go. Pop out. All right. First in chat was Janice. It was Janice with a gifted membership. Congratulations, Janice. We're gonna send it to you with the internet ownership, Janice. It's all yours. We're going to make sure you handle everything on your end so that we can do everything on our end so that everyone else can listen to the show. So wonderful. Thank you so much, Janice. I appreciate you being willing to take one for the team, honestly, and get this set. All right, as we are, this looks really funky like that. I think I just need to only show one at a time. There we go. All right, let's bring in this right here, because let me tell you what we're oh, that's not it. This is the Sarah Boone letter. As interesting as that was, that's not the one we're going to read tonight. We are reading this guy over here. Oh, buffer. Why do we have a buffer? Oh, it was Bad Squirrel Decisions? Bad Squirrel Decisions. I do apologize. I thought I had pinned the message.
Stuff that is not relevant.
I tease you with the fake Sarah Boone letter. I would never do that. Never. Let's see. Let's pull this up. I had it on my screen, and now I've got so many things open. I've lost it here. Nope. Yep. Okay, now we've got it. I think I've got 7 virtual monitors running off this one device, and I wonder why it runs slowly. But here we go. Let's add this to the stage. I'm going to come over here so you can see me down in the corner. Does everything work? Is everybody happy? It's still pinned. I see it down here. I see Bad Squirrel Decisions over here. I just can't pin it on StreamYard for some reason. So, all right, we're gonna turn down the volume here as you guys start using the sound effects just a little bit more. But Bad Squirrel Decision. I take back everything I said about someone else winning the internet. In fact, it was you. You have won the internet. It's all yours, and we're going to send it to you with it. Make sure you go over and buy your own copy for the low fine of 50 cents. Buy your own copy of your internet ownership certificate, which is suitable for framing or uses a cover sheet on your resume. All right. Now, why is it so important? Why did I interrupt your evening on a Monday night to tell you about a filing in a court document? Glanville did a 180. Alex, you're absolutely 100% right. Glanville did a 180 today. And Judge Glanville, in the Young Thug case, completely reversed pretty much every decision he has made to this point, other than the fact that he's always said he's right. The issue at hand is a secret ex parte meeting he had with a sitting sworn witness and the prosecutors without defense knowing about it. Well, we have hot off the press tonight, the transcript of that meeting, and we're going to go through every bit of it in its goodness, its juicy goodness. There's a lot. Now, I apologize because when I'm reading, I'm not going to be able to watch chat. So I can go catch up if there's some starred messages and things. I can catch up to those, but I just won't be able to see them all as they happen. Lenova, welcome back. Says I missed you guys. Sorry, I need to just shut this computer off because because I need to not click there and I need to click over here instead. Lenova says, I missed you guys. Thank you for the super chat. Lenova, hopefully your new age is treating you well, as you recently had a birthday. Congratulations. Can you remove the floating heart, please? I will remove that right now before we get going so that everyone can read this along with us. We're about to start reading. We've got to buckle in. Now, this is a court transcript, and court transcripts are notoriously long, right? Let me fix this first. There we go. Customization and live reactions. Heart thingy is gone. It's gone as of right now. All right. Let me go to this here. So you can see the whole thing. Oh, good. Full screen works. All right. This is hot off the press. July 7th. Sorry. Let me start again. July 1st, 2024 at 7:45 p.m. This was just barely filed out of Fulton County Superior Court. This is the case of that we know it as the Young Thug case. And you really called Recovery Addict because you find the documents. On this one, I owe this to my wonderful mod, Samantha, found this for me. I put out the bat signal earlier today saying we're looking for this. If anyone knows where it's at, please let us know. And she found it. Rob Lawn Lumber is here. I swear I'm not going to click on that one anymore. I'm going to like move the mouse so I can't see it. Let's see, where did Rob go? He says, I've got to be on this side. Rob, I'm going to find you here. Just one second. I says, hi, folks. I'm here. This is the fastest way for me to digest this stuff while doing live stuff. So glad Scott saw this. Cheers, my friend. I'm going to read through it. Rob, you have to explain it. So if we can tag team on this one, that would be great. One thing I'm not going to do is I'm not going to do all the voices. This has several different parts, lots of actors in this one. So let's get this underway. Transcript of the ex parte hearing in the chambers of the Honorable Ural D. Glanville on June 10th, 2024. And it's got Christina Weaver. She was the one who typed this up for us. That's wonderful. Appearance of counsel on behalf of the state. We had Adrienne Love, Simone Hilton, assistant district attorneys. Also on behalf of Kenneth Copeland, who was the witness. We had Kayla Bumpus. That was the attorney at law. She was a fill-in lawyer. First day she ever represented him was that day, and the last day too. The ex parte hearing began at 9:10 a.m. Present in chambers were Judge Glanville, assistant district attorney Adrienne Love, and attorney Kayla Bumpus, court reporter Christina Weaver, and investigators Antonio Long and Rashid Hamilton. Court reporter says, okay, I'm ready whenever you are. Mrs. Love says, thank you. The concern that we wanted to bring to the court's attention as a state was twofold. One, we wanted to have an opportunity to impress upon Mr. Copeland with the representation present that he faces, and we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him in the courtroom when the jury came out. The second that I have is that I wanted to bring to the court's attention, in line with the concern that I expressed on the record on Friday. I don't know what advice counsel may have offered or may be offering. That is their right and their business. As it relates to testifying, however, I do not believe that criminal exposure is a concern that is which is just being spoken about and protected. Mr. Melinek relayed to Ms. Hilton on Friday that he had never heard of the statute 24-5-507, and on Friday he sent an email. I don't know if he intentionally copied Mr. Steele or Mr. Shart, which is an unfortunate name, but I don't know if he unintentionally put my name on it. But he sent an email to Mr. Steele and Mr. Shart with me and Simone copied, and where he said, this is the communication that I received from Mrs. Love regarding Mr. Copeland. My response was, whose interests are you protecting, yours or Mr. Steele's? Whose clients? Which client are you protecting? Whose client, yours or Mr. Steele's and Mr. Shart's? He wrote back and said, you're going to get him killed. You're making him a target. Oh my goodness, we're going to have some of these. You is what he wrote in the email. So given that his concern is that by testifying at least the one that he conveyed to me in writing, his concern has nothing to do with exposure from the state. And if his concern, the judge says, his being whose concern? Mr. Love says, Mr. Melinek, if the interest is that he's protecting Mr. Copeland's freedom, he did not convey it by asking us that exposure. What exposure does he face in testifying? In fact, he's concerned that testifying will get Mr. Copeland killed, and he is not communicating with us. He's communicating with counsel for the defendants. It would seem that he knows a thing or something that we don't know. Additionally, I will let Mrs. Bumpus tell you. He has said if Mrs. Mr. Copeland testifies he's no longer representing Mr. Copeland, which is strange because if your interest is in your client, then it would seem you would want to be there for him while he's testifying. Judge says, well, he's on vacation this week. Mrs. Love says, I understand. That is why we has Miss Bumpus here. And he has said what he has said. As I was reading the statute, the thing that okay, give me a second. Her speaking style is a little hard to catch here, and I want to do it justice. Mrs. Love continues. She says, and as I was saying, reading the statute, the thing that is, and I was reading the statute about this particular situation, and I was reading our rules, our ethics rules of conduct for attorneys, and it is clear that if an attorney, there are two things that were happening. One, Mr. Melinek has told me that he wasn't Mr. Copeland's lawyer. Mr. Copeland has told Miss Hilton that Mr. Melinek wasn't representing him. And then rather than Mr. Copeland reaching out to Mr. Melinek apparently was in communication with Mr. Steele and Mr. Shart. And Mr. Melinek reaches out to Mr. Copeland and ejects himself in these proceedings. What we were discussing was in no way a matter that Mr. Melinek was representing Mr. Copeland on, and that is where we're not allowed to speak with the person when they are represented by counsel. Mr. Melinek was not and could not have been representing Mr. Copeland on anything we were talking about because we were there talking about this case and this trial. All that aside, we would like an opportunity for court to address Mr. Copeland with Mr. Copeland's stand-in counsel present, Miss Bumpus. It's looking at me. Oh, Miss Bumpus is looking at me like there's a look there. Miss Bumpus says, I'm listening. Mrs. Love, with his standing counsel present and to allow Miss Bumpus an opportunity to explain to Mr. Copeland everything that I have just said. Her concern outside was what is the longest he can stay in jail. What I relayed to her is the statute says until he purges. The court says by testifying. Mrs. Love, purges his contempt by testifying. Judge says, yeah, 507 is a little bit different. So, I mean, Miss Bumpus, so until the end of this? Judge says, he can be here until the end of the trial. Miss Bumpus, that is what I said. To the end of the trial is the longest? Miss Love, no, it's not the longest. Even after a grand jury, if a person has been subpoenaed to testify before a grand jury, and even after the grand jury has, convened, has left, the person that can stay in, she doesn't know what it means to have a grand jury convened. The person can stay in until that person purges himself of contempt by testifying. The statute literally says that. Miss Bumpus says, well, I'm going to look it up because it was my understanding that it was until the end of the trial. Miss Love, nope, Here it is, literally the words of the statute. And so judge interjects and says, he could be in there a while. Let's put it that way. Either way, Miss Bumpus says, I just want to be able to give him. The court says, I know. It's kind of the statute says, that you purge, but I can't keep him there in there indefinitely. I've got to kind of, Miss Bumpus says, right. This is all I want to know. Judge says, the whole thing is that he has the keys to his own freedom. And that freedom is if he just gives his testimony, then he's purged it. Miss Bumpus says, right. Miss Love says, and whatever that testimony is, we know what we believe it to be, but we don't know what it is. We can't talk about it. We don't, we don't know what he's going to say. We have an idea. We know what he's told us. Miss Bumpus says, yeah. Miss Love says, and our concern is that I know the court has said essentially you intimated that Mr. Melinek probably told him essentially you should testify that you are going to. They're not going to. They can't do anything with your testimony. But what we overheard being said was they're going to hammer you as if we were going to expose Kenneth Copeland to. Miss Bumpus says, you heard that? Miss Love says, yes. Mr. Melinek told Mr. Copeland we're going to hammer him. Judge says, now to be fair, I think Miss Bumpus has an advocate or anybody has got to tell him he's going to face some pretty significant cross-examination. Miss Bumpus, yeah, I think that's what he meant. Court says, he's got about 10, Miss Love. So he meant the defense is going to hammer him? Miss Bumpus, no, just in general, he's going to be, it's not going to be, hey, da. Miss Love says, he knew that. He'd already been expressing that. Judge says, but I think that if he's concerned about that, well, but it's all in the message and the packaging in terms of, I think Mr. Copeland is, a savvy person, but, he's certainly going to be the subject to a thorough and sifting cross-examination. Miss Love says, and the other thing is that Miss Bumpus interjects, can I just say something in Attorney Melinek's defense in response, just for the record? Miss Love, yes. Ms. Bumpus, the reason that he doesn't want to move forward with representation, what I've been told, if he decides to testify, is that he doesn't feel he doesn't know what was said outside of his presence. So he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. Ms. Love says, but the thing is, the only thing that he should be concerned about is the criminal exposure, or the exposure that Kenneth Copeland has criminally. And there is nothing. There is literally nothing. The statute's quite clear that we can do to him about the only thing that would put him in harm's way is a lie and a refusal to testify after being ordered to do so by the court. And by a lie, we don't mean like, oh, I think you're lying. It would have to be, something obvious, because we can always impeach. But if he literally perjures himself, that's something different. We can't help that. We can't control that. We would only say, tell the truth. I don't care how bad it is. Just tell the truth. So, like he says, it didn't go down to the police station. I didn't go down to the police station. The court interjects and says, I think part of this challenge, Miss Bumpus, may be that you need to assure him, look, I'm going to be there. And if you think that they're asking you a question, they being the state or the defense, is asking you a question that's going to bring out other crimes, that he's going to be able to look at you and say, can I have a chance to talk with you? Miss Love, that's exactly right. Miss Bumpus says, uh-huh. Miss Love says, see, but that's just it. Miss Bumpus, no, he's not. Miss Love, hold on. That's just it, Judge. The problem is there's been an assertion that people are representing, and I'm not talking about you. Miss Bumpus says, yeah. Miss Love says, there's been an assertion that people are representing that their best concern is his best interest. And then they're just not here. And Miss Bumpus is saying she's not in a position to do that. Miss Bumpus says, no, I'm not saying that I'm not in a position. I'm saying that the agreement between Mr. Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm going to get him to sign this paper that says that then discharges Melnick as his rep. That's their agreement. I can't do nothing about that. Miss Love says, that sounds weird. That does not sound like something Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I can't. I'm not going to represent you. I don't even know what to do with that. Miss Bumpus says, well, he said he does not know what was said. Miss Love says, it doesn't matter what was said. Miss Bumpus, right. Miss Love says, it doesn't matter. And he didn't ask us. He didn't even inquire. What have you all talked about? He has been talking to Brian Steele and Max Shart. That's it. He's not talking to us. And in fact, when Mr. Copeland asked to speak with us, Mr. Melnick barges in and gets between Miss Hilton and Mr. Copeland and literally keeps us from talking to him before he gets called to the stand. And that's troubling. Ms. Bumpus says, well, I think what happened was, and I say this because I previously represented Mr. Copeland previously on his other stuff. So I know this is just what I think happened. I think how Attorney Melnick came involved was this representation of because he took my place, Copeland fired me and hired Melnick. And then this came about. And I think so at the beginning, Melnick was representing him. And then Miss Love says, in this criminal matter that he had, but that's resolved. Miss Bumpus says, but when this case started, Melnick called me and told me that he was representing him as a witness at the beginning. I can assert that. Miss Love says, Melnick has never in life. Miss Bumpus says, this is 2 years ago. Miss Love says, Melnick didn't. As a matter of fact, less than 2 years ago when Copeland was sitting in jail for something else he had done, Melnick said, I don't represent him. He told me, I don't represent him. And people were in the room. He was on speaker. He told me he didn't represent him. Now, he ultimately did come about and represent him. But when we were trying to get, I guess, Miss Bumpus says something, yeah. Miss Love says, Copeland was like, he's not my lawyer. I don't have a lawyer. He's not my lawyer. And then Miss Bumpus says, are you talking about recently? Miss Love says, so recently Copeland said that Melnick was not his lawyer. Miss Bumpus says, right. Miss Love says, when Copeland was in jail, Melnick told me he wasn't his lawyer. But our understanding was that Melnick was his lawyer for those criminal charges. And so the person that came in and argued or at least stood in for him on his bond and then on his subsequent plea was Melnick. But I don't know whose interest he would be representing when he's not talking to us about what we've spoken to Copeland about. He could ask us what we could tell him. What we would tell him, so I don't know why he would withdraw his representation of him. If his interest is Kenneth Copeland, then why would you pull out? That doesn't make sense, says the court. Miss Love says, at the point where he would face the most peril, if that was his concern, if his concern is, I don't know what they talked about, so I don't know what, court jumps in and says, and I thought that Miss Hilton had a list of questions for Mr. Copeland anyway. Miss Love says she did. Court says, well, how come you all can't? Miss Love says, he didn't ask to see those. He didn't, and not only that, Court says, well, can't you all share that with Miss Bumpus? Miss Love says, well, Miss Hilton has already shared it with Mr. Copeland, and we certainly will share it with, generally speaking. Miss Bumpus says, can I read this email that Melnick sent me? I don't know if this will help you understand what he's saying. It says, hey, Kayla, I wasn't able to see Kenneth today. He went on Saturday and tried to talk to him before his flight. But I have talked to his family. So at first, Kenneth was going to testify, but now has decided to take the 5th. He may change his mind on Monday. If he does, then he's agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA's office, so I can't really help him with this testimony. And then he gave me the discharge and told me that if he decides to testify, then he's to sign this. Miss Love says, and that's just it. It's like you never know what somebody is going to ask. And if he's concerned about putting him in legal jeopardy, then it would seem like he would remain and allow Mr. Copeland access to counsel when Mr. Copeland is concerned about what he's about to walk into in an area that puts him in legal jeopardy. Miss Bumpus says, you can't switch now he gets called. How he gets called? Miss Love says, see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. When you switch and say how he gets called, what does that have to do with anything? Miss Bumpus says, I don't know. Maybe he's saying I can't do it because he can't get his refundable ticket. Miss Love says, that's not what he said in the email to you, and that's not what he relayed to the court. And his concerns have nothing to do with, the court said, he was very much, Miss Bumpus continues, I tried to go back and watch as much as I could. The court says, telling me what, they're talking at the same time. This is why the court reporter hates people talking at the same time. Tell me what that he was going on vacation. And I said, well, you inserted yourself. I said, this is still the court. I said, really? You need to come on Monday. Miss Love, so he can't force Mr. Copeland to discharge him just because Mr. Copeland decides to testify. Court says, I think you are in until it's done. I mean, Miss Bumpus says, who, me? Court says, yeah. I mean, that's just, if he testifies, you've got to kind of, Miss Love says, and frankly, Your Honor, I know that if a person faces criminal contempt, they are entitled to representation if they want it. This being a civil contempt matter. Judge says, not necessarily. Anybody who's facing contempt can get counsel. I mean, not anybody, but Miss Bumpus says, I can't stay. How long is this going to take? Miss Love says, might take some days. Miss Bumpus, Miss Love says, and see, that's just it. And I think Miss Bumpus is put in a precarious position. She's not the one that stood up and injected herself into this. They reached out to her and she did him a favor. But ultimately, it seems as if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings. And that is a problem because that has nothing to do with the best interest of Kenneth Copeland. And that has nothing to do with Kenneth Copeland's exposure if he testifies. Just to answer the question about what he is exposed to, the statute is very clear. It literally says that no testimony or any evidence required under the court's order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning which he testified or produces evidence under the court order. That's a pretty broad protection. That is saying, even if he got on the stand and said, Judge interjects, he started talking about an unrelated crime, which is what the biggest thing I think he's probably thinking about is, yeah, there's a lot of stuff they could ask me about. Miss Love says, right. Court says that is not known to a lot of people, and that, he could also invoke his Fifth Amendment with the advice of counsel if it was some other particular crime. But Miss Love says, but even that the court says, even that he'd still have to testify. Miss Love says, literally, right. The saw says, I think she meant law says. I think she's meant law says instead of saw lays. Court says, yeah, I mean, anything he testifies to. Miss Love says, we do this. Miss Bumpus, okay. And then about the delay or stall, isn't it true that, or is it not true that he had a leave filed since December? Miss Love said, we have nothing to do with any of that. He injected himself into this. Court, yeah. See, the problem is, Miss Love says, he stepped in. Court says that when you get involved, I don't know you have a leave. Miss Love says, right. And unless you filed that leave into this case, you don't have a leave for my case. Miss Love says, right. Miss Bumpus, okay. Miss Love says, and he did not. Court says, so he didn't have one. Miss Love, Mr. Copeland's been a witness and a name on this witness list since. Court says, so since he said, well, I represent him. I'm like, okay, well, don't you have a leave that's filed in our case? Miss Bumpus, okay. Miss Love, so he did this to himself and he did it to you. They're talking about the attorney, but we have to, this is just where it is. And I don't know what that's just where we are. Miss Bumpus says, so Judge, you're going to make me stay if he chooses to testify? The judge says, I am, because you're his lawyer. You're his lawyer. You're a stand-in lawyer at this point. Miss Bumpus says, Your Honor, I don't have a problem with that. I'm not ready. Miss Love says, Court says, there's nothing for you to be ready about. I mean, here's the thing. I think the only thing you've got to kind of ask him about is, look, here's the questions the state's going to ask you. All right. Is there anything else that could hurt you that they might ask you about? As long as you have knowledge of that, then I think that you're fine, because the state's only going to get into this. Now, the reason you want to know what's going to hurt you is the defendants know more about Kenneth Copeland than anybody else. So they're probably going to kind of, Ms. Bumpus says, what about if I say I can't do it? Then Melnick needs to come back, right? Am I going to be in trouble because I was only for Monday? That's what I was told. I was given specific. Ms. Love says, if Copeland said, I don't know what Mr. Copeland wants, it's his choice. Ms. Bumpus says, can't he say he doesn't want Melnick? Ms. Love says, he can say whatever he wants. It's his choice. Ms. Bumpus, but the judge is saying, Ms. Love says, I don't think he can. I don't think he can be forced to have representation if he doesn't need, or say he wants it, because we've done everything to clear him of judicial exposure. He's not. There is nothing he can say. He could lie. That puts him in, the court says, peril. Ms. Love says, peril. But, he can't talk about a crime that we could then prosecute him for. The court says, that is involving this or some other place. Ms. Love says, right. This is where they're talking about he could say that he killed the guy. Ms. Bumpus says, I don't understand that. Ms. Love says, and we can't use his testimony to find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded. Ms. Bumpus, I would have to agree with you that I don't think that's the concern. Isn't that what you said? Ms. Love says, well, the court said that. Ms. Bumpus, no, I'm saying with Mr. Copeland not testifying, you said you don't think that his concern is criminal exposure, or do you think that that's what he's worried about? Court says, do you think that he's fearful of testifying for other reasons, like for his personal safety? Ms. Bumpus, right. Ms. Love says, that is what Mr. Melnick said to me in an email I can pull up. He said, Ms. Bumpus cuts in, but you don't believe that. Ms. Love, you're going to get him killed, is the quote. That's what he said. We ain't going to kill him. Ms. Bumpus, see, I don't know anything about that email. Ms. Love says, we ain't going to kill him. I can show you the email, but we're not going to kill Kenneth Copeland. So who is he talking about? So what are you trying to do? The court says, that is a collateral second and third order effect. Let's pray it doesn't happen. But Ms. Love says, I mean, obviously the judge continues, but first he has to give testimony, though. I mean, that's what he has to do. He's got to give testimony, whatever it is, good, bad, or indifferent. Good, bad, or indifferent, I should say. Ms. Love says, so we would like, with the court's permission, they haven't brought him over, and he was supposed to be the first one up. So I guess they went to get him. They might be over here with him now. The court says, is he here now? Ms. Love, I don't know. Judge Glanville exited the chambers at 9:33 a.m. Ms. Love continues talking. We would like to just go into another courtroom and talk to him, give him a chance to talk to him, and then give you the opportunity to explain to him. Court reporter says, we're off the record. Brief recess. Judge Glanville and Mr. Chamberlain entered chambers at 9:34, 1 minute later. Ms. Love says, Ms. Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. Court says, where's Mr. Copeland? Mr. Chamberlain says, they took him upstairs to the tank in 9. Court says, okay, can we bring him out to, Mr. Chambers says, your chambers is being used. I mean, your courtroom is being used. The court said, let's bring him in here. Mr. Chamberlain, all right. So let's see if we can get that done. The court, let's bring him in here. Okay. Thank you. We'll just bring him in here. The proceedings stood in recess from 9:34 to 10:03 a.m. Mr. Copeland enters the chambers at 10:03 a.m. Also present were Judge Glanville, Assistant District Attorney Simone Hilton, and Attorney Kayla Bumpus, Court Reporter Christina Weaver, Investigators Antonio Long, Rashid Hamilton, Deputy Houston, and Deputy McPherson, Sergeant Brown, and Sergeant Hall with the Fulton County Sheriff's Department. Judge says, okay, Mr. Copeland, can you let him know I got a hearing problem? Miss Bumpus, okay. He said, he is hard of hearing. The court says, that makes 2 of us. I've got a hearing aid, and that's coming on the 27th of June. So I'll try and talk loud. Is it okay if Mr. Copeland said, yeah, I can read lips. The court says, okay, good. Mr. Copeland, good morning. Mr. Copeland says, good morning. Judge says, all right, I just wanted to bring you over and let you talk with Miss Bumpus and see if there's anything that you need to ask of your counsel or Miss Hilton or the state or the court before we bring you out this morning, because we would like to hear your testimony. And that is kind of where we are at this point in time. So is there anything you want to ask? Mr. Copeland says, well, I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of the stuff that's going on. This is the first time I've ever told the truth in my life, he says in this statement. Court says, okay, well, the only thing you can give us is truthful testimony. I mean, whatever you know is whatever you know. I mean, that's it. Ms. Hilton says, and what we'll say, and Mr. Copeland and we have talked about this. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week. But if any of your concerns deal with being locked up for anything, you can't. Like, there's nothing that can happen. The feds, Ms. Bumpus says, well, that's not. Ms. Hilton says, it is true. Ms. Bumpus says, no, I said that's not his concern. Ms. Hilton says, if his concern is safety, we need to know that. That's not expressed. So we don't know what the concern is, so we can try to resolve the concern. This is what I'm saying. Mr. Copeland and I have had conversations before. I understand some of his concerns is potential criminal liability, hence why we gave you immunity. The federal statute of limitations, done. The state statute of limitations, done. So there is nothing. Like, I researched it this weekend again. Both those statute of limitations for what you and I talked about, which is in 2015 and before, done. You cannot be prosecuted for anything you testify federally or statewide. Immune, period. So if that is the concern, there is none, because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been 2020. Anything statewide is 4 years, would have been 2019. Finished. Next concern, what may happen in the street? You know what we've talked about, what we can do as far as living and all that. We've had those conversations. So I'm trying to express to you, we do not want you locked up. I don't know how many times I've got to tell you what I've got to say to you. We do not want you sitting in DeKalb or wherever because of this. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Miss Bumpus, I'm here, but we do not want you in custody. You will not. Did you say talk without your lawyer? If you still want to talk without your lawyer, wow. You will not. This order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution. Any of it, literally. Judge, you might want to close your ears. If you confess to a murder on the stand, Judge, you might want to close your ears. Then the prosecutor continues. If you confess to a murder on the stand, if we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. So again, I don't know what is communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Mrs. Bumpus, as I told you before, that is what this order says. Judge says, and that is direct or cross-examination. Ms. Hilton says, and that is direct or cross-examination. The court says, so if you're worried about what the defendants may ask you because they know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Mr. Copeland says, I got family members watching this trial, and I don't want my nephew and them to hear the things that I may be involved in and think it's okay. Ms. Hilton says, but I think that's a separate conversation you can have with them as an honest individual. Like, look, nephews, I've lived the life that I don't want you to live. Don't go through what I've been through. But that's something you can have outside of being in jail, because there's a better conversation you can have with your nephews in person. But they shouldn't have to come to the Cobb County Jail because you're being held in contempt. You can have that conversation with your nephews tomorrow in person. You can have that conversation with them. You can have that conversation with anybody. You know what's coming up this weekend? Why are we in jail? What are we doing? Mr. Copeland said, but y'all did this intentionally. Ms. Hilton, no, we did not. You and I had this conversation, Mr. Copeland, on Friday morning. Mr. Copeland says, you knew my child's birthday was next week. Ms. Hilton says, but what did I tell you? When we met with each other, I said to you, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And what was my response? If you plead the fifth. And that is exactly what you did on the stand. Mr. Copeland says, but what did I tell you before I got to that point? I told you the whole time Tuesday, Wednesday, Thursday. Ms. Hilton said, but I told you we were giving you immunity. Mr. Copeland said that I was pleading the fifth. Oh, I told you the whole time Tuesday, Wednesday, Thursday that I was pleading the fifth. You cannot put a witness on the stand that's going to plead the fifth. Ms. Hilton said, no, you did not. Mr. Copeland said, I told you every day I was pleading the fifth. Ms. Hilton said, no, you did not. And we told you, Mr. Copeland, I told you my concern. Ms. Hilton says, and we said we could give you immunity, but you said your concern is that they know about you. And when you said that, I said, well, you know stuff about them. And I said, whatever your concerns are, we can give you immunity. Mr. Copeland says, so I didn't tell you I lied to them on that to get myself out of the situation? Ms. Hilton says, you said you were a liar. That's what you said. You said you were a liar. Ms. Bumpus says, was this recorded? Ms. Hilton, no. Ms. Bumpus says, and did he ever say that Melnick was his attorney? Ms. Hilton says, no. This week, when he first met you in the car on Friday, we asked you, is Mr. Melnick your attorney? You said, he's not my attorney. I haven't even talked to him. Mr. Copeland says, oh my goodness, this is bad, guys. Mr. Copeland says, no, I've never said he's not my attorney. I said I haven't talked to him. Ms. Hilton, you said he's not your attorney. You haven't talked to him. And then we continued to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick in here. Hey, put Mr. Melnick on the phone. Mr. Copeland said, you didn't make me feel like I needed him. Ms. Hilton says, but if you needed him, we would have said, and if you would have needed Mr. Melnick, we would have said to you, okay, just call him. So, I mean, that is our position. We don't want you in jail. We just want you to be able to purge yourself by testifying. Whatever your truth is what your truth is. But you've just got to answer the questions. We believe that whatever your truth is what your truth is. We know what you've said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. I know what you said before, and I know what you said later. I mean, I know what you said before, and I don't know what you're going to say on the stand because you and I never went to the full details about any of it. But what I don't want is you sitting up here in custody. Mr. Copeland says, you did it. Ms. Hilton says, I did not do it. You did it by pleading the fifth. Mr. Copeland says, you told me before you went to the judge with whatever the thing you went to him with, you told me that I can't. When I asked a question, I can say, I don't recall, or I don't know. You told me that if I plead the fifth, I mean something, why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do. And then you was like something. And you all asked for this immunity. And I was like, it was something. And then Thursday or Friday came, and you all go to tell me, oh, we went to the judge with this, so you got to testify. If you don't testify, the judge is going to lock you up. Ms. Hilton says, right. But that was based on what Mr. Copeland says, but I told you all that. Ms. Hilton, no, you didn't. Mr. Copeland said, you said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened. Ms. Hilton said, and I said, I don't know what happened. Only you know it and them know. I said, but you never said I'm pleading the fifth. You said, what if I do this? What if I do this? What if I do this? Mr. Copeland says, I told you, I said I'm going to plead. You said, why would you plead the fifth to something that you didn't do? Ms. Bumpus says, so if you didn't have immunity prior to, is that what you were saying? That you feel like he didn't have immunity prior to? Mr. Copeland said, immunity came Friday, right when I went to jail. Ms. Hilton said, the immunity only came after Mr. Melnick. Ms. Bumpus says, hold on. Ms. Hilton says, the immunity came after Mr. Melnick sent us an email saying my client is pleading the fifth. That was on Thursday evening at 6 o'clock. Ms. Bumpus, okay. Ms. Hilton, so after that was an emphatic, he is pleading the fifth. Ms. Bumpus, uh-huh. Ms. Hilton, we came and we got this signed. Ms. Bumpus, uh-huh. Ms. Hilton, and then Friday morning came. Ms. Bumpus, okay. Ms. Hilton says, so between Friday evening, Mr. Melnick reached out to us. He said he represents him. He's pleading the fifth. Ms. Bumpus, okay. And when was the last time you talked to him before Melnick got involved? Ms. Hilton says, we talked to him earlier that day on Thursday. Ms. Bumpus says, okay. Then speaks inaudibly to Mr. Copeland. Mr. Copeland says, he called me. Ms. Bumpus says, okay, I was just trying to get a timeline. Ms. Hilton says, sure, right. We've been talking since last Friday. So I met with Mr. Copeland last Friday, I think out in the neighborhood. Then he came on Tuesday for court. We talked briefly about on Tuesday, and then on Wednesday he came. Mr. Copeland, Thursday. Mr. Hilton says, no, I think he only came 2 days. So it had to be Wednesday and Thursday he came. It wasn't Tuesday. It was Wednesday and Thursday he came. And then on Thursday, once we left, is when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at that point is when we went the next morning and got the immunity motion. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we can't use. And then Mr. Melnick came, and then we had court. Ms. Bumpus says, so you're pretty much saying you didn't ask for this? Mr. Copeland says, I didn't. Ms. Hilton says, but we gave it. He doesn't have to ask for it. Ms. Bumpus, I know. I mean, he's just saying, Ms. Hilton says, right. He doesn't have to ask for it, but to alleviate whatever his concerns were, we gave him immunity. He didn't have to ask for it. Ms. Bumpus says, so if he wouldn't have had this, I'm just saying this so he can understand it. I'm walking him through. Ms. Hilton says, uh-huh. Ms. Bumpus continues, would he still have had to testify or would he have been able to plead the fifth? That's what he's saying. Oh, my goodness. Oh, my goodness. That is gold. Ms. Bumpus just hit the nail on the head. Ms. Hilton, if he did not have immunity? Ms. Bumpus, yes. Ms. Hilton, yes, he could plead the fifth. Mr. Copeland, that's what I'm... Ms. Bumpus, that's what he's trying to say. He's trying to say he didn't ask for this. Ms. Hilton said, but he doesn't have to ask for it. Now that we have given it to him, because that's on us. So now that we have given it to him, it's an order. He can still choose if this is the road he wants to take. Then he'll have to just stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried. Not just these 6, the other ones too. Mr. Copeland says, I did longer time. Ms. Hilton, all right, Mr. Copeland, I'm telling you, you are literally immune from prosecution from anything else you may say. That's that. So the choice is always up to you, but we wanted to put on the record the state does not want you in custody. What the state would like from you is to purge yourself from... Mr. Copeland says, what purge yourself mean? Ms. Hilton says, meaning that you are no longer in custody. The way that you purge yourself is to testify. That is kind of how it happens, and that's what the state wants you to do. We don't want you in custody. I can't say that any other different way, but we don't want you in custody. The only thing that's holding you is refusing to testify. Judge steps in. So do you have any questions, any other questions? Basically, if you invoke the fifth, Mr. Copeland says, I don't trust. I don't know what's going on. I don't trust nobody. I don't trust her word, but I don't know what's going on, Your Honor. Ms. Hilton says, this is your insurance. I don't know if you want to break that down to him. Ms. Bumpus says, well, he doesn't want that. The court says, but he's been given it. See, that's the challenge, Mr. Copeland, is that if they didn't give you the immunity, you could invoke your Fifth Amendment privilege. But what the state decided is they said your testimony is worth more to them at this point in time than they really want to know, and they really want to know what you have to say. So they have made from the state's perspective, they've made a decision to give you immunity so that you no longer can invoke your Fifth Amendment privilege. You have to testify. This is dirty. Oh my goodness. So that's the difference in this particular scenario, is that they have taken away, well, you can still invoke your Fifth Amendment privilege. You can still do that, but the consequence of invoking it is you will remain in custody. So if you testify, you get out of custody, and you stay out of custody until you're done. Mr. Copeland says, and then if I don't testify, I have to stay in until when? The court says, until the trial's over, until all the defendants, I've got these 6 that we have right now, and then there's another 6. Ms. Hilton says, no, there's another 12. Judge says, there's another 12 or thereabouts that are still have outstanding in various forms or another. Mr. Copeland, can I speak with her for a second? Court says, sure. Judge Glanville, Assistant District Attorney Simone Hilton, Court Reporter Christina Weaver, and investigators Antonio Long and Rashid Hamilton left the chambers at 10:17 a.m. and returned at 10:33. Mr. Copeland then says, my question is, I can ask you a question. The court says, yes. Mr. Copeland, so my question is, so what I was just asking her was, if you ask me a question and you feel as if I was lying about it, you will lock me back up? Ms. Hilton says, no. So you're saying I didn't talk to Dame Keon? Well, no, I can't talk about that because the judge is in there. Well, no, I can't talk about that because the judge is in here. Oh my goodness. You're asking, for example, that if you said that the sky was blue and I asked you on the stand, what color is the sky? And I said it was red. I'm going to say no. Back before you said it was blue. Is that what you're trying to ask me? Ms. Bumpus says, uh-huh. So explain the independent evidence. If he says he did something and you know he's not telling you the truth, what happens? Ms. Hilton says, if he said he did something and he did not do that thing? Ms. Bumpus says, if you believe he did not, so if you believe if you believe that he's lying about that. Ms. Hilton says, then no. If he admits to doing something on the stand, Ms. Bumpus, uh-huh. Ms. Hilton says, and he did not do that thing. Ms. Bumpus, uh-huh. Ms. Hilton, I'm going to say, is this the first time you're saying that? Ms. Bumpus, and then you have independent evidence to prove it wasn't him. Then what? Ms. Hilton says, then nothing. What do you mean, like? Ms. Bumpus says, so then he'll be fine? Ms. Hilton says, yes, but Ms. Bumpus, so you're okay with him if he got on the stand and said things that weren't true? Ms. Hilton, no, I want him to tell the truth. What have I always said to you? I want you to tell the truth. I don't know what's going to come out of your mouth. I expect you to tell the truth. If you say something that's inconsistent with what you said before, then I'm going to ask you about the inconsistencies, but I expect you to tell the truth. What you go on the stand and do, I don't know. I don't know what you're going to do. I want you to tell the truth, but I will deal with you not you saying something different in the manner that I normally do. Mr. Copeland says, if I'm saying something different, right? So when the police question me, then they done question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I've done told them. Ms. Hilton says, okay, so you can say, I don't recall. That is how it works. I don't recall. Ms. Bumpus says, and he can say that to every single question. Oh my goodness. Ms. Bumpus for a fill-in lawyer. Great job. Oh my goodness. This is great. Ms. Hilton says, I would hope that is not the truth because I think there are some things you do recall and some things you don't. But the things you don't recall. And then we'll go through my process of what I do. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk about him about what impeachment is if he says, I don't recall. Mr. Copeland says, what will get me locked up? Ms. Hilton says, what did I tell you? Mr. Copeland, I don't know. Ms. Hilton says, what you did on Friday, I plead the fifth. If the court instructs you, Mr. Copeland says, so the only thing that gets me locked up is pleading the fifth? Ms. Bumpus says, yes. Ms. Hilton says, the court instructs you, you need to answer the question. You say, I plead the fifth. Again, that's what's going to get you locked up. But if you answer the question, that will not get you locked up. Mr. Copeland says, so if you don't want me in jail, why don't you just let me go after the trial over with? Ms. Hilton says, you're in jail because you're not answering the questions. Court says, because you've been given immunity. Ms. Hilton says, because you've been given immunity, you're only in jail because you got up here. Mr. Copeland says, well, what about this? I answer the questions, you take away immunity. I answer the questions, and I plead the fifth. Ms. Hilton, no. Mr. Copeland, to questions that I feel incriminate me. Ms. Hilton, but then Mr. Copeland says, I won't plead the fifth to things that don't incriminate me. Court says, the state can still give you immunity. They can give immunity to whoever they want, okay? They can make that choice. I don't even make that choice. So if they, like I said earlier, they want your testimony, they figure it's that the jury needs to hear what you have to say, good, bad, or indifferent. And what Ms. Hilton is telling you is just tell them the truth as you know it and let her worry about, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. What will get you into trouble is you just invoking the Fifth Amendment privilege because you have been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. That particular false statement. Mr. Copeland said, that's what they're going to do. Ms. Bumpus, that is what I'm saying. You'll be right back here. Ms. Hilton said, but if you say something that you know and you did not do, like you admit to something you know you didn't do, Mr. Copeland says, like murder. People do not get to have it their way. Like murder. Don't have no statute of limitations, right? Ms. Hilton says, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but to you saying it. Mr. Copeland says, but y'all don't Ms. Bumpus says, you can charge him with false statements and he'll be back in jail. That's what I'm trying to say. Ms. Hilton says, but if I know that you are lying about that, and I do not intend to do that. If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know what your reason is for doing that. But I'm not going to charge you when I know that you didn't do what you're trying to say you did. And that could be part of this. I know you didn't do it. Mr. Copeland said, but it's up to the judge to do that. Ms. Hilton says, no, it's up to the state to bring charges. Judge says, I don't have anything to do with that. Ms. Hilton says, he has nothing to do with bringing charges. That's up to the state of Georgia. Mr. Copeland says, can I talk to my family and I'll make my decision right after I hang up the phone? Ms. Bumpus says, he's saying he hasn't been able to speak to anybody. Ms. Hilton said, his sister just called us. Mr. Copeland said, y'all done me wrong. Y'all just hold me in the jail. Don't let me get no PIN number, no nothing. Ms. Hilton said, we have no knowledge. We did not know that you. Ms. Bumpus says, he hasn't been able to do anything, speak to anyone. Mr. Copeland says, the jail system don't, but y'all still putting people in. Miss Hilton says, that part I don't know. I know we have been in communication with your sister. Your sister actually texted Mrs. Lenisquo, I have no idea how to say that word, Miss L, to make sure you were okay. We told her physically, we had physically laid eyes on you. I'll leave that up to the sheriffs. I don't know. Brief pause. Mr. Copeland says, so what you think she's saying, Miss Hilton, I can tell you right now, Mr. Copeland, I'm talking about that locking me back up. Miss Hilton says, we would have to bring charges. There would be no incentive. Mr. Copeland says, y'all will. Miss Hilton, we've already had this discussion. Mr. Copeland, look what you did to me. You waited until Friday and did this. I done told you every day before Friday I came here I was pleading the fifth. Miss Hilton said, no, you did not. As a matter of fact, the court says, Mr. Copeland, let's see if we can get beyond this, okay? Beyond what your concern is. You could have invoked the Fifth Amendment privilege. The state could have turned around and said, stop. Had me go ahead and filed that motion and given you immunity. It was going to, they make that decision. They decided to make it on Friday. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness. They want your testimony more than they do you invoking your Fifth Amendment privilege. So they give you immunity. They give you immunity so you've got to testify truthfully as to what your knowledge of the particular incident is. So if they were going to, they could have done that anyway. Even if they were to put you on the stand, they could have said stop and gone ahead and given you immunity. They could have done that. Mr. Copeland says, so I can get it in some type of writing that I was to testify that if she feels that I lied about anything, that they won't lock me back up. The court says, let me have that, Mr. Bumpus. Miss Bumpus. Miss Bumpus hands the court document to the court. Brief pause. Court says, Mr. Copeland, on page 2 of the order, pursuant to OCGA 245507. However, no testimony given by Kenneth Copeland as required under this order, or any information directly or indirectly derived from the testimony of Kenneth Copeland, given by Kenneth Copeland as required under this order, shall be used against said Kenneth Copeland in any proceeding or any prosecution for a crime or offense concerning which he testifies under this order. Okay, so you testify about some aggravated assault or murder. They can't prosecute on it because it is what it says in the order. Okay, so the only thing that will get you in trouble is this next little paragraph. Kenneth Copeland shall be subject to prosecution or penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court in this state, United States, or any other state. So basically, if you commit perjury, false swearing, or contempt committed in testifying, that means if you just invoke your Fifth Amendment privilege or failing to testify, you say, I'm not going to testify. All right. So the only two real things you can get in trouble for are perjury and false swearing, as long as you tell the truth. And now, as Miss Hilton and Miss Bumpus have said earlier, you may have told or have been asked about situations over and over again. They may have changed. What the state is asking you to do is tell the version that really is the truth. If they want to impeach you, they can do that. Or if the other side wants to impeach you, they can do that. You won't get in trouble for that. Mr. Copeland, you said I will. The court says, you will not. You will not. Impeachment is not perjury or false swearing, okay? Mr. Copeland, but you said I can purge myself, though. Ms. Hilton, no. We're saying two different things. Sorry. Perjury is that if you get on the stand and you say just a bold-faced lie, just something that is wrong. You say, I did something, and all other times you have said, I have not done it. And really, well, it's perjury. It's really just an inconsistent statement. Like if you get on the stand and say, I did X, but in 2015 you said, I never did X. That is what I'm going to impeach. I'm going to impeach you on everything you said in 2015, meaning I'm going to say, okay, today you said I did X, but in 2015, Lieutenant Dean enters the chambers. Lieutenant Dean says, we have a security issue. We need to stop for a minute. If we can stop for a second, please. Judge Glanville and Lieutenant Dean exited chambers at 10:45 a.m. Judge Glanville returns 2 minutes later. Ms. Hilton says, I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for YSL, period. So why would I want that for you? That doesn't make no sense. I said it to you before. I will say it to you again in front of all these people. It makes no sense. Mr. Copeland says, you just said I'm going to have to stay in jail until the last. Ms. Hilton says, if you don't testify, get this part through your head. If you don't testify, that is the only thing that is holding you. That is literally the only thing holding you right now is the fact you keep saying, I'm not going to testify. Well, you haven't said it today. I'm not testifying. I plead the fifth. If you get up there and I want to tell you, I want you to tell the truth. Like I said before, if you don't recall certain things, you can say you don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail from 2015. I just don't. No one here does. But what I do expect for you to do is to answer questions so we can get through this. So you can go home, be with your baby for her birthday, see those dogs deliver their babies, go talk to your nephews, and do all those other things. Mr. Copeland, how do you know about my dogs? Miss Hilton, because you told me, Mr. Copeland. Okay. Miss Bumpus, what's wrong? Mr. Copeland, I'm stressing at another level. Like, Miss Bumpus, I mean, I'm saying, Mr. Copeland says, I'm weak, man. I'm not playing. I'm dead serious, man. Like, Miss Hilton says, this is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That is what will get him out of jail. And, you have to make, Miss Bumpus says, if he decides in 2 weeks that he wants to testify, then what? Miss Hilton says, if he wants to stay in jail for 2 weeks, then I don't know why you'd want to stay in jail for 2 weeks. I have no idea. Miss Bumpus says, he just feels like he's under a lot of pressure right this second. Mr. Copeland says, even at the jail, you can't give me house arrest? Miss Hilton, no. You can go home by taking the stand and testifying. That's what the court says, and come back tomorrow. Miss Hilton says, we keep on saying yet, but there is no crime. You keep on saying yet. I don't know who is telling you about a crime. There is no crime. You have done nothing wrong except for not. Mr. Copeland says, so why am I in jail then? I love that. Miss Hilton says, because you aren't testifying. Mr. Copeland says, but that ain't nothing wrong. It's not a crime. Miss Hilton says, it's not a crime, but you're in civil contempt. The court says 2 things. Because you invoked your privilege after you've been given immunity, that is why you're in the custody, because you get out by testifying. So you testify, you get out. That's why I was going to why I brought you in here early today, just to inquire about that. You can remain and hold your position of invoking the 5th or not about testifying, but you go back to prison. You go back to jail because Mr. Copeland says, you can't sentence me? Ms. Bumpus says, there's no sentence. The court says, there's no sentence. The contempt is compliance. They want your testimony. That's all they want, whatever that may be. Mr. Copeland, I don't know what it is, Your Honor. Ms. Hilton says, so listen, you're in jail for failing to testify. The court says, failing to testify. Ms. Hilton, not for nothing else. There is no crime. You ain't done nothing. I don't know if people are telling you that we are going to charge you with nothing. We are not charging you. The state charges you. There is nothing we're charging you with. You are only in custody because you've decided not to testify. That is it. Once you decide to testify, court says, remember the word we were talking about? Purge? Mr. Copeland says, uh-huh. The court says, okay, you can purge right now. Purge. Get yourself out of jail just by testifying. Mr. Copeland says, I can purge and get out of jail? The court says, yes, just by testifying. Ms. Hilton says, not perjury. The court, purge, meaning you can get out of jail. You can get out of jail, out of custody, just by testifying. Mr. Copeland says, and what about the other one, the other word, perjury? The court says, that's different. Ms. Hilton, that's different. The court said, that's a different word, okay? Mr. Copeland says, that can get me back in jail? Ms. Hilton says, yes. The court says, perjury is, Ms. Hilton, it's not what you're saying is not perjury. What you're saying is not perjury. What you're saying is that we call a prior inconsistent statement. Your example that you gave me, what if I said I did something that I know you didn't do, and you said it before you didn't do it? That's not perjury. That isn't prior inconsistent statement. Brief pause. Ms. Bumpus says, you've got to make a decision. So if he starts testifying today, he's going to go home today? Mr. Hilton says he should, so long as he remains. But if you get up there and be like, if you get to testifying and then we get into it and you start saying, I plead the 5th, we're going to be right back here again. Ms. Bumpus says, but if he says he don't recall to everything, he'll be okay? Ms. Hilton says, I'm not advising that, but so long as he answers the questions, that's fine. So long as Mr. Copeland says, I did these crimes. I'm telling you that. Ms. Hilton, okay, I don't know what you're talking about, but Ms. Bumpus says, I think you're saying you want to get up there on the stand and say something? Mr. Copeland, no response. Ms. Bumpus says, did we find out if he could talk to his family? No? Brief pause. Ms. Hilton says, I mean, it's okay. We've got the sister's number. Mr. Copeland says, as my attorney, you gotta. Ms. Hilton says, if y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak low so he doesn't hear you. Court says, hold on. Judge Glanville handed a document to Attorney Kayla Bumpus and exited the chambers with Assistant District Attorney Simone Hilton, Investigator Long, Investigator Hamilton, and court reporter Christina Weaver from 10:53 to 11:28. Now the court comes back, says, okay, all right, Mr. Copeland, have you had an opportunity to talk with Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions? Mr. Copeland says, no, Your Honor. Court says, is it your desire to give testimony today? Mr. Copeland says, yes, sir. Whoa, I'm just seeing chat. We'll get to that in just a minute. The court says, okay, all right. Do you all have some clothes for him? Ms. Hilton says, I don't know. Let me take a look. What size are you? Mr. Copeland says, I can't hear you. Ms. Hilton says, what size are you? Mr. Copeland says, little. Investigator Hammond says, we had a large jacket for him on a Friday. Large. Ms. Hilton, you had a jacket for him? Investigator Hamilton, yes. Ms. Hilton, oh, but he can't wear a large. The court, what size is your waist? 34? Mr. Copeland, 32. I remember those days. Court says, chest, what are you? A 34, 36-inch chest? Ms. Hilton says, probably 36. Mr. Copeland, not of my chest. What do you mean? The court says, size. Ms. Hilton, what size are you? Ms. Hilton says, what size are you? Small or medium? Mr. Copeland, small or medium? The court says, they're going to try to get you some clothes so you don't have to testify wearing that jail uniform, okay? Mr. Copeland says, y'all don't want to show the people how y'all did me? The court says, look. Ms. Hilton says, if we can't find some clothes, then you may have to until tomorrow. Mr. Copeland says, I prefer to go in like this. Ms. Hilton says, I understand what your preference is. Mr. Copeland says, nah, don't hide it. Ms. Bumpus says, can you make him put on clothes? Ms. Hilton says, no. Mr. Copeland says, I want to go in here like this. Ms. Hilton, fine with me. Court says, all right, okay. Mr. Copeland, you ain't going to try and lock me back up for this? Ms. Hilton, so long as you testify, we will get an order to get you released. Ms. Bumpus, today. The court, whose copy is this? Ms. Hilton, you've got to make sure you come back now. I want to be real clear. Mr. Copeland, when have I ever ran? Ms. Hilton, you have not. That's the only thing. You have not. The court, whose copy is this? Ms. Hilton, that was ours. Do you want a copy? You can take it, though. Ms. Bumpus, okay. Ms. Hilton, do you still have yours or you threw it away? Ms. Bumpus, I'm going to give him both of these things so he can have some information. Ms. Hilton, okay. The court reporter says, are we off the record now? The court, are we done? Ms. Bumpus says, yes, I believe so. The court says, okay, we're good. See everybody downstairs in about 10 minutes. The proceedings concluded at 11:31 a.m. And here's the certificate. I hereby certify the foregoing transcript was taken as stated in the caption and the colloquies, questions, and answers were reduced by 2 typewriting under my direction, that the foregoing pages represent a true and correct record of the evidence given. I've only found 2 errors. And I further certify that in accordance with OCGA 91128A, I am not a relative, employee, attorney, or counsel of any party, nor am I financially interested in the action. This is the first day of July 2024. Christina Weaver. 56 pages. One more time with feeling, says Greeners. From the top. Let's take it from the top. Wow. This is I don't know if this is illegal, but oh my goodness, this is a dirty trick. This is so dirty. We have, let me see if I can get my screen up so I can see where we're at. Okay, 7. There we go. We have Mr. Copeland feels like he's done dirty, and he was. He literally, he's in there to testify, not under an immunity deal. Okay. And he's saying, I'm going to plead the 5th. I'm going to plead the 5th. So what does the state do? They go out without him asking for it. They gift him. Oh, out of the goodness of our heart, we're giving you an immunity deal. What does that do? It takes pleading the 5th off the table. They cannot do it. I mean, he cannot plead the 5th. So when he does plead the 5th, now he's held in contempt because it's a violation of the immunity deal, which he did not ask for. This was brutal. They did him dirty, and it's right for him to feel wrong about this. This is crazy. This whole trial is nuts. But finally today, Judge Glanville, has finally done what he should have done the moment the motion was made to this, calling for his recusal. He should have followed the Georgia law and immediately turned it over to another judge to look at. First of all, look at it on the face of the document, make sure that the document is accurate, has the necessary parts as required by law. Then consider on the part that lists the evidence or the reasons for recusal, if they are true, not whether or not they're true, even if he has personal knowledge that they're not true, but if they are true, could that be construed as some sort of bias, an impropriety, and then turn it over? He didn't do it. He waited and waited, and now today it looks like someone has gotten to him. Someone's talked to him and said, "There's problems here. You've got issues. This needs to be handled differently." And now he's pulled back. He said he's canceled the meeting with Miss Bumpus, because remember, right after this meeting, like at the end of that transcript that we just barely finished, they came out in court, and Miss Bumpus made a motion to withdraw as attorney for Mr. Copeland. And the judge didn't want to let her go. Fought and fought. Mr. Copeland's like, "I don't want her. You fire her." And she's trying to quit. And finally he had to let her go, but he did so only with the caveat that she had to come back and testify in a show cause hearing, because he was still trying to figure out who ratted out the secret meeting, who told about it. Anyway, he's flipped his story around. He's canceled that meeting. He's no longer interested in finding the mole, probably because they went through the court security camera videos and think they pinpointed the actual exchange with Mr. Steele, and Miss Bumpus looks to be the source when she had a conversation with him on camera, and he called that out and says, "We have that. We know what happened." He still is saying that he says nothing was wrong with what they did. He's standing by his reasoning that this was a legal and proper meeting, even though all the laws and rules and guidelines say that, for no reason, only under extreme circumstances would you want to have an ex parte meeting like this. But just bizarre. And so what happens while we're trying to read this breaking news? Apparently something happened with Proctor. What in the world happened with Mr. Proctor today? The trial is over and Mr. Proctor has been rehomed. Community of Massachusetts State Police relieve Trooper Michael Proctor of duty and formally transfer him. Okay, this screams that the lie it means that the press report they made when they had the mistrial this afternoon, that we're going to re-prosecute, we're going to bring this charge again. I'm not so sure if they are firing the lead prosecutor and transferring him as a result of what happened here. I'm pretty sure this one just might never come up again in court. Who released the transcript? Ms. Hayes, that's a great question. The judge in the Young Thug trial did not want this transcript released. The attorneys asked for it. They demanded it. They demanded to know what happened, and the judge refused to release it. In his mea culpa complete 180 that he turned today on almost every topic, he decided to release the full transcript ahead of turning this over to a separate judge who is going to review the ex parte meeting and the request for his recusal and make a ruling on that. So the whole Young Thug case is on hold until that ruling comes back from the other judge. The state has requested that it be expedited if at all possible, which I don't think they really can. But they want to expedite it because they're holding a jury. There's a jury that's been here for a long time and is still continuing to be held here for a long time. Proctor, lead investigator or lead prosecutor? He was the lead investigator. Did I say prosecutor? We're talking about two trials. That's obviously the Karen Reed trial, but that is big. I did see that there was somebody went to his house, Mr. Proctor's house, and asked for a statement, and he said, "Get the off my lawn." And yeah, he's not happy. Any questions? Any parts you need me to go back and reread? Holy cow! This is a crazy day in the world of true crime. Oh my goodness. I apologize. I'm not seeing we're live streaming on Twitter as well as on YouTube right now, and I have not been paying close attention to what's been happening here. Let me put a couple things up. Let's see. Janice gifted a membership to kick things off. Thank you very much. Lenova also says, thanks for going live again. Missed you guys. Thank you, Lenova. Appreciate that. Ricky Watson gifted 5 memberships. Thanks, my friend. Good talking to you the other day. Let's see. Selena K gifted 1 Recovery Addict membership as well. Pantoufle says, don't know about the case, but I'm here for an epic RA reading. This was a tough one. I feel for court reporters after reading this. Transcripts are tough. Whodunny, member for 8 months, says something they made to mob boss Giacana to force him to testify against the mafia in the 60s. Immunity to remove the 5th. Insane. It's a dirty trick. It's so dirty, especially when they knew, apparently, okay, they're adamantly saying it didn't happen, but the witness, who may be lying, has said, I told you 3 days in a row, I'm going to plead the 5th. I'm going to plead the 5th. I'm going to plead the 5th. And then, surprise, you came out and said, here's this gift. We're going to give you this immunity. You don't have to worry about it. Now you can testify. It sounds like he told them they're going to plead the 5th, and they had that deal put together. Now, what can you not do if you know you have a witness who's going to plead the 5th? You can't put him on the stand in front of the jury and have him plead the 5th. And it looks like they knew that this was going to happen. Oh man. Okay, so now I've got to catch up on what's happening with the lead investigator, Mr. Proctor, Massachusetts State Police. Let's see if there's some. Let's see here. Let's see if there's a statement here. Massachusetts State Police. Colonel Mond's statement following the mistrial in the Commonwealth versus Karen Reed. Oh, wow. I'm reading this verbatim. This is the Massachusetts State Police press release just up from this afternoon. Following the mistrial in Commonwealth v. Karen Reed, the Massachusetts State Police would like to offer our condolences again to the family of Boston police officer John O'Keefe. We cannot imagine the way in which this result has heightened the O'Keefe family's immeasurable grief, heartache, and sense of loss. John lived a life of honorable service, both to the city of Boston and the children entrusted to his care after the unexpected death of his sister and brother-in-law. We will remember him. Upon learning today's result, the department took immediate action to relieve Trooper Michael Proctor of duty and formally transfer him out of the Norfolk County District Attorney's Office State Police Detectives Unit. This follows our previous decision to open internal affairs investigation after information about serious misconduct emerged in testimony at the trial. This investigation is ongoing. Our focus remains on delivering the highest level of services with professionalism and integrity. That's a quote from Colonel Mon. The department has relieved Trooper Proctor of duty effective immediately. He will also be transferred from the detective unit assigned to the Norfolk County District Attorney's Office, effective Sunday, July 7th, 2024. The collective bargaining agreement requires a 5-day notice for any change of assignment, shift, functional role, etc. For this reason, the effective date of Trooper Proctor's transfer from NCDAO is effective on the first possible day, Sunday, July 7th, unless otherwise agreed to by the parties. In any state police discipline process, the trooper is subject to a duty status hearing where he will be retained on full duty, placed on restricted duty, suspended with pay, or suspended without pay. So that's the latest from the Massachusetts State Police. Seems funny that they just found out about it during trial. How do you retry the case with the lead investigator looking like that? I mean, how do you retry the case and keep that out? That is absolutely crazy. He's been rehomed to where? Yeah, and who now has to deal with him? What little town has Trooper Proctor now issuing traffic tickets? I don't want to drive through that town. I want to know where he's going. I want to know where his duty has been reassigned to, unless it's cleaning something somewhere with a broom, maybe corrections somewhere. Clean up janitorial work and corrections. Is that a good move? They've had it in Discovery since. Yeah, they've had it forever. This is too little, too late. Guess what's going to happen tomorrow? Tomorrow we're going to have the Canton Select Board meeting, the town meeting, which has always turned into a huge fight. It's going to be awesome. We're going to be bringing that to you live tomorrow night, because Mr. Albert's on there. The older Mr. Albert. So it's going to be interesting because a lot of people are going to have a lot of things to say in light of this. All right. Transfer him to Dayton. That's not good. That's not good. I feel like this is step one. He'll be officially fired. The investigation can lead to that. The police union is rather strong. The union is pretty good about that. He gets 5 days for any reassignment of a shift or duty, things like that. That's pretty standard. He will have a job until the investigation's over, or unless he decides to leave voluntarily, which is possible. If he knows how it's going to end, he might choose to do it on his terms instead of having to blow up. Oftentimes, if they leave voluntarily, it tends to not release all the information out into the public like being fired might do. Everything's hitting the fan. Megan, it is. These comments tonight, they're pretty good. I apologize for missing all that. It was what we were reading, the 56 pages of transcript. But thanks again, once again, to Samantha, our amazing mod. You know her. She's probably welcomed you to a live stream at least once if you've been on when we were live at regular hours. But she found that for us as soon as it dropped, and we knew we had to bring that to you so you guys could have it to enjoy tonight. So, all right. Anything else you guys want to cover tonight while we're here? Anything else I need to know? Is there any other news that broke in the last 5 minutes? We heard it here first. You're welcome. I love doing the readings. I think that's it gives me insight. Next time I'll try to do better, and we'll do voices. Maybe we'll do sock puppets, and it might be easier a little to understand if we do that. About Mr. Copeland, did he ever sign it? They can't enforce it if he doesn't consent, right? They can, Kaylee. Apparently, it's not something you get to choose or even have to accept. Once it's been gifted, it's like internet ownership. Once it's gifted, you just have it, and tough luck. Can you imagine how bad the city would be if the verdict was actually reached? It would be riots. I think you're going to see quite a bit of change in Canton over the next couple of years if the people who want change can stay focused and united. It's very difficult to stay united when you're looking for change in a community. Everyone has a direction they want to go, and they end up pulling against everyone else, and you end up not making any change. And you end up with the same thing as always. But it appears that the upcoming elections on the select board as well, primarily is going to be the target of that. So the select board just barely renewed the police chief's contract, which the town was a little upset about. At least the people who weren't townies were upset about, and so they'll probably have some heads roll. There, breaking news: Mrs. Ra's clothes are in the dryer. I do need to rotate the clothes in the laundry tonight. Okay. I think you can waive an immunity agreement, but you can't waive it and then plead the fifth. But so you don't get immunity, but you can waive the benefit, but not plead the fifth. Lenova, thank you for the super sticker. I appreciate you. You've been a huge supporter of the channel. Thank you. Thank you so much. Sarah Boone fired her last attorney. Herself, you heard it first. The letter we read today from Sarah Boone, if you haven't heard, there was one more letter from Sarah Boone. It was actually written and submitted prior to the judge ruling that Sarah Boone had lost she had her last publicly assigned attorney. She's not going to get a free attorney anymore. She now has to pay for an attorney if she wants one. Otherwise, she's pro se. She sent that letter before she found that out, but now she knows. And it's interesting because in that letter, she's like, I'm looking forward to who you're going to send next. And nobody else is coming, Sarah. It's all you. It's all you by yourself. Plus, she does not have money to hire an attorney. So she's really up a creek right now. We do expect another letter from Sarah Boone, probably within the next week, addressing this issue because she found out about being pro se there in that hearing. And I'm sure she has a lot to say about it once she got back to her jail cell, thinking about how that's going to happen. Late but present says, thanks for my pre-bedtime story. If that's what it takes to sleep, glad I can be here for you. Late but present, appreciate that. She hired Treehouse Guy. Don't think so. You can't, to be hired, you actually do need to have a law license. Practicing law without a license will get you in a lot of trouble in pretty much every state. The only exception to that is when you are acting as your own attorney, where everyone has the right to do that, barring, barring a ruling from the judge that you're not capable of that. It is bedtime. It looks like we're coming up on 10 o'clock East Coast time. We've got an early morning. I don't know what's going to break tomorrow. This has been an incredible day in the world of true crime. We'll be keeping an eye on a couple of the big cases moving forward. We're coming up on Alec Baldwin in the trial, the Rust shooting trial. That's going to be very insightful. We've got about a month out before we find out what's going to happen with the Karen Reed trial. That's going to be on the 22nd of July, the hearing in the afternoon where they decide if they're going to prosecute again. It really puts a big question mark on that when Proctor has been fired. See, early morning, I was hoping to sleep in. Nope. No sleep for the wicked. Can you fingerprint the turtle? I think you fingerprint their shell. Their shell is unique on the outside. Red Pen, thank you very much. Lady Jaconis, thank you. It's been wonderful having you here. I have not followed what's happened with some of the characters outside court. I do know that there's some cases involved sort of peripherally to this trial. Yeah, crazy day. Loving it. Yeah, what a great hobby. True crime. Days like today will keep you hopping for sure. Lazy Retired Lady, good to have you here. Thank you very much. Leonard PHL. He's just on leave, sadly. Leave is the first step. They can't go straight to firing someone. There has to be an investigation. It has to be done properly. That's the way the union has written the contracts. Margaret, be safe on the road tomorrow. Orbit, that's crazy with Turtle Boy. I'm not going to go too much into that, mostly because I have not followed that story close enough to know where it's at. But I believe there's some charges against him for possible witness intimidation or something like that. I don't remember exactly what charges they filed against him, which is why he had to be removed from court, or why he was not allowed to be present in court during some of the witnesses' testimony. But it's good. All right. I think we're good. Leave, investigate, fire, go back to charge mistrial. Nice. All right, I think we're going to wrap it up with that. You guys, it has been wonderful to have you guys here. This is what I like to think is the best place to watch true crime, and that's because of this amazing community. It is wonderful to be here. I love the comments. I love the amazing mods that make this all happen. Let's see, Krista, I see you here. Still can't pronounce your last name. He wants to play with the toys. We have buttons. I keep checking. I've got another button. I've got another. It's one of these, but it's about that big and it has 87 buttons, and it's going to be coming here this month, is what I've been told. It's going to be here this month, and it's going to be working with our replay unit to do really quick replays if we want to do rewind, slow motion, things like that. Super excited. So more buttons soon. Thank you all. You guys, tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again. Tomorrow morning, 8:45 in the morning, I'll try not to be late. I make no promises, though. Love it. You guys are amazing. Be good to each other. We'll see you in the morning. Bye-bye.
The zombie apocalypse may be upon us. This is not Burger King. Do not just have it your way.
When are we going to break for lunch, Judge?